Here are some things that you need to know to determine the probability of your DUI being dismissed in the state of California. There's a lot of variation, but typically when we refer to a DUI being dismissed, it could be interpreted in so many different ways. For one, having your charge reduced from a standard DUI, for example, 23-152A or B, to reduce to a 103.5 or 23-103, like reckless driving or 647, public intoxication, or maybe to the extreme, disturbing the peace. So technically, it gets reduced and the standard DUI is dismissed. Usually that can happen when there's a weakness in the case, when there is some form of mitigation provided, negotiation informing the district attorney that this particular client does not deserve a standard DUI. This is not a person who falls in the category of a standard DUI. Another way of when a DUI can potentially be dismissed is if there's any form of constitution violation. Before an officer can even make an arrest, they have to make a stop. And in order to make a stop, the stop has to be some form of reasonable suspicion that the person is committing a crime, such as a traffic violation, which is very common for DUIs. This is where the officer gets the time to observe the driving. This is very key. Observing the driving is going to be one of the most important components in determining if there was actually driving or under the influence type of standard. Oftentimes, this is something we want to investigate. Was there an actual legitimate basis to stop, or was this like a pretextual type of stop? This is where you get your DUI defense lawyer to evaluate it and to see if there's any potential defenses. Another way is once they stop, there has to be some sort of articulate information to do further investigation. You stop for a traffic violation, such as, let's say, running a red light, and now, if there's no additional information that the person is under the influence, then it should be very quick citation and off you go. Oftentimes, officers tend to go a little further. They tend to try to fish, ask questions, where'd you come from, and etc. You do have a right to remain silent during that situation. You are being interrogated to some extent. Though you may not be in custody, there can be an argument that can be made under that circumstance. So now, if you are taken out to be investigated, now the question is whether or not that investigation was proper. And then after that, whether or not the arrest was proper. These are things that we are evaluating to determine if any of that is proper, because if any of those procedures were improper, then it could be a potential Fourth Amendment violation, or in other words, unreasonable searches and seizures by government. If you or anyone you know is facing a DUI and you feel like your rights have been violated, or you think that there may be a potential weakness in the case, make sure you contact us at wshaw Law Firm so we can evaluate it.